Almost every first-year Civ Pro class is going to spend a considerable amount of time on international shoe. International shoe, distilled to a single point, is this. In order to be subject to suit in a particular state, you must have minimum contacts with that state. The reason is that one who has sufficient contacts to gain the benefits and protections of local state law implicitly accepts the good with the bad. If she accepts the benefits and protections of the law, she also accepts the reciprocal burden of being hauled into state court. There are three basic points that come out of the minimum contacts test that you have to know. Number one, we don't really care about the plaintiff. The plaintiff gets to choose which among the acceptable fora to file her lawsuit. But we only look at the defendant to decide which fora are acceptable. Number two, not every forum has personal jurisdiction over the defendant. And number three, it's the defendant's actions that determine whether a state has their personal jurisdiction over that defendant. And this really makes a lot of sense. A Seattle native who's never stepped foot out of Washington state shouldn't be made to defend a case in Puerto Rico, for example. Because personal jurisdiction is there to protect the defendant has the right to waive jurisdiction. Waiver can come in two basic forms. It can be explicit, such as by contract, which is actually very common, or it can be implied, such as by failure to raise personal jurisdiction at the proper time, in the proper manner, using proper procedures, which we'll talk more about later. In the absence of state law requiring otherwise, incorporation in a state is not sufficient to create minimum contacts if the defendant has no other business in that state. That's the Schaefer-Greyhound case. And it's actually very common, by the way. A lot of corporations incorporate in Delaware, despite that they have no business in Delaware. When assessing whether an organization has minimum contacts, we look no later than the time when the suit commences, which the federal rules define as the time the plaintiff files his complaint. The defendant cannot defeat jurisdiction in the middle by breaking all ties to the forum state, such as by moving out of the state. Now, typically, we're actually going to look before the plaintiff files. Typically, the facts that govern the case and the time that they occur are the relevant time to assess personal jurisdiction. Just as the defendant cannot defeat jurisdiction by moving out after the time, whether it be the time of the underlying events or the time that the plaintiff files his lawsuit, the plaintiff cannot gain jurisdiction simply because the defendant happens to move to a new state in the interim. So, for example, if Acme Corp. Enters into a long-term contract with a business in New Mexico, and at the time of the contract has no business in New Mexico whatsoever, but opens a branch there 3 years later, it's at best uncertain whether there would be personal jurisdiction over Acme in New Mexico for a suit relating to a breach of the underlying contract. Why is that? It's not simply that we care that the defendant is in the state, which the defendant now is, they opened up an office, but that jurisdiction over that defendant was foreseeable at the time of the underlying events, that is, when they entered into this contract. So the question of jurisdiction is going to turn not on the fact that Acme is there 3 years later, but on whether the original contract gave rise to minimum contacts at that time, such that suit in that state was foreseeable. Relating to corporations, the officers and agents of a corporation establish its contacts if and only if the agents were acting within the scope of their duty and on behalf of the corporation at the time they make those contacts. So if a corporate manager enters into a series of contracts with another business in a particular state on behalf of the corporation, or one of the corporation's operating divisions, that's probably enough to subject the entire corporation to personal jurisdiction in that state. However, the opposite is not true. Just because minimum contacts exist with regard to the corporation, because of the acts of one of its officers, that does not mean that personal jurisdiction exists for all of the officers and agents in their personal capacity. It would surely violate the fairness rule to subject all of a corporation's officers to suit in a state simply because the corporation has contacts in that state.